Greetings, everyone, and glad the message went out about our slightly later starting time. Greetings to all those joining us both in South Africa and internationally for the the fourth part of our 10th part series on climate change. I'm Professor David Bilchitz, the director of the South African Institute for Advanced Constitutional Public Human Rights and International Law, which is a center in the Faculty of Law at the University of Johannesburg, and we are delighted to be the hosts of the series. The series was created to bring together leading experts who would explore various aspects of climate change from the perspective of multiple disciplines. And through the carefully designed topics, we delve into science, law, policy, and social justice questions, and will expose participants to the key debates that occur in these areas. I want to pay tribute to the multidisciplinary organizing team for their vision and leadership. They are Professor Kitty Dumont from UNISA, Dr. Jenny Hall from University of Johannesburg, Professor Diane Hildebrand from UNISA, Professor Lwazi Ngubane from Wits Business School, and Professor Colleen Fogel from the University of the Witwatersrand. I also want to thank our partner Constitution Hill for their support and all those who've helped advertise the series. And from the SAIFAC side, I would like to thank Ropa Fatso Maposa for her work on the administrative side and Ibrahim Karim for designing our posters. Tonight, we only have 100 places in the Zoom conversation, but we are live streaming on Facebook, and I welcome our viewers on Facebook. We are delighted to have with us today the keynote speaker, Professor Christina Voigt of the University of Oslo. Welcome, Christina, and thank you for joining us. Our next seminar will be delivered by Dr. Dolf Giesen. He's the Director for Innovation and Technology of the International Renewable Energy Agency, and he will address the topic, who produces CO2 and why? What are the options and technologies for reducing greenhouse gas emissions? And more details will follow about this, but the date, please diarize, is the 8th of July, 2021. And of course, the time will be 5:30 South African time. And I'll post the RSVP there. I'm now going to hand over to the chair of the seminar, Dr. Jenny Hall. Dr. Jenny Hall is a senior lecturer at the University of Johannesburg Faculty of Law. She moved into academia full-time a couple of years ago after a career specializing in environmental law and servicing all sectors, including drafting legislation, policy, and strategy, and one of which was drafting South Africa's first climate change discussion document for government, together with the late distinguished Professor Bob Scholes. So without further ado, I'm going to hand over to Jenny, who will conduct the seminar. Jenny, over to you.
Thank you, David, and warm welcome, everyone. And again, apologies for the delay and start, but I'm very sure that it'll be worthwhile. Also, special welcome tonight to our friends from Siberia and Tyumen University. There's a few of them that are joining us. So a lot of our audience is following on Facebook, but it's great to see everyone here. So for those of you who've been following this series, tonight we're shifting gear. We're moving into another one of the disciplines, and that's law. And law is also an important discipline, not always the most popular discipline amongst my colleagues, but an important discipline because in theory, at least, it gives expression to the will of the people. And we've certainly seen a growing will of the people around climate change, with climate change demonstrations throughout the world, but also because it makes binding rules for what the other disciplines are necessary. But as with other disciplines, we've in the legal world, it has its own struggles and challenges. And particularly in the international law space, what we always have to remember is making law is slow. It's not a quick process. And one of the reasons that it's not quick is that we need consensus to get there in the international space, at least. And so law can be criticized for not being as ambitious as it should be. But we have the best speaker to enlighten us on that, and that's Professor Christina Voigt. She is a professor in the Department of Public Law at the University of Oslo. Her CV is literally too long to read because it's so impressive. I'd encourage you to Google her online because you can read all the details. But what can I say? She's an expert in international environmental law. She's worked a lot on climate change law, which is what we're interested in. She has published prolifically, including on climate change law. She also is not one of those lawyers that often we get criticized about being in academia, of being in our ivory towers. She has led Norway's negotiating teams on the RED Plus negotiations, and she's been a lead advisor to the government of Norway on climate change negotiation for many, many years. And excitingly for us, she's also the first co-chair of the Paris Agreement implementation and compliance and enforcement committees. So it's a great privilege to welcome her, for her to share her insights. She will be followed by two respondents, our homegrown exciting people, Dr. Melanie Moocott and Mr. Louis Kuhn, but I will introduce us later on. Christine, I know you were struggling with your PowerPoint, but I'm seeing it up on the screen. So can I hand over to you?
Thank you so much, Jenny, and thank you, David, for your most kind introduction. And before I start, I want to express my sincerest apologies for having had to delay for 1 hour this talk. So thank me. It was my mistake. I got the time zone wrong and I had another appointment. So I thank you very much. And I thank the audience for your indulgence. So thank you for your patience. Well, in my talk today, I'll offer you a bit of a mixed bag of, looking at law, looking at what we have in international law that addresses climate change, looking also at the indirect effects of the treaties that we have on other areas of law, before we then open for questions from the audience, because there's so many different things, and I'm most interested in the questions that you may have, and maybe the discussions are more interesting than the PowerPoint presentation that I have. So I tried to stick to about 30-40 minutes, and then we should have time for discussions. So thank you all for joining us today. So I'll use the first couple of minutes to talk about the Paris Agreement, because of course, as you know, this is the most important treaty out there. And it's not just because of the agreement itself, but also because of the legal repercussions it has on other areas of law. I'll explain very briefly the basics, how it works, because it is very important to understand it in order to understand its power and its limitations. And then I'll talk a little bit about the rulebooks, the rulebook that was adopted 2 years ago, and which hopefully will be finalized now this year in Glasgow. Before that, in the second half, which is number 4 here on this slide, I'll look at the wider, let's say, Paris Agreement ecosystem that we have out there, the legal ecosystem. Next slide, please. So when it comes to law and climate change, the question is often why do we need law? And we need law in order to translate science and political will, hopefully, into concrete action on the ground. There is really no other tool that regulates behavior. That's why we have law. But climate change, being that global challenge, needs a collective response, because it is a collective action problem, as you know, caused by many contributors all over the globe, but also over a very long time by emitting greenhouse gases into the atmosphere with accumulation over time, and now causing that phenomenon of global warming. So in order to address a collective action problem, we need a collaborative or cooperative response by those who caused it, but also by those who have the capacity and the capability to address that problem, but also including those that are most vulnerable to the challenges of climate change, to the impacts of climate change, but haven't really caused the problem or may not even have the capacity to deal with it. So it's a collective action problem, but it is also an equity problem in terms of global space and time. And that calls for the widest possible participation in an international, no, just stay there, one slide back, in an international treaty. So over the years, for the last 25 years, we have had several treaties that have been adopted under international law. That is the law between states, where states agree amongst each other what to do. And it started with, in 1992, the United Nations Framework Convention on Climate Change, which entered into force just 2 years later and still is in force. It's still the overall background agreement, but it didn't really offer an effective solution to climate change because it was not specific enough. It's just a framework agreement which set climate change on the international legal sphere, but it wasn't specific enough. And then, as you may know, we had the Kyoto Protocol, which was adopted in 1997, and it's still there, but it's just running out of its second commitment, or ran out of its second commitment period in 2020, and there won't be a third commitment period. And it really only obliged a number of developed countries to reduce their emissions, so it did not address all relevant emitters. And then finally, the last point here is, of course, the Piers Agreement, which was adopted in 2015, and it entered into force in record speed just a year later, and that is what I will focus on. If you can switch to the next slide, next one, yeah, here. So the Piers Agreement didn't come out of nowhere, and Jenny already indicated to the challenge of making international law. Now, as you all know, as I indicated, the Framework Convention on Climate Change wasn't effective enough. It was very clear very soon that another treaty under the convention was needed, which was more specific, more concrete, which included all countries, and it had to be adopted on a consensual basis. I'll come back to that in a second. And that was attempted already in Copenhagen in 2015, but it failed. It failed for several reasons. I don't have the time to go there, but only 2 years later, in, did I say 2015? 2009, 2 years later in 2011, the member states to the United Nations Framework Convention on Climate Change got themselves together, got themselves motivated again, and adopted what was called the Durban Mandate. And that set in motion a new negotiation stream that ended in 2015 with the adoption of the Piers Agreement. But it was based on this mandate. And you see what I highlighted in red there was that the mandate was to negotiate a new agreement applicable to all parties, which meant it was meant to draw in every country in the world, basically, on that global effort of climate change. Next slide. And it was adopted in 2015, and it is a legally binding treaty. Now, what does it mean? A legally binding international treaty is an agreement between states, and it is legally binding. Does not necessarily mean enforceable. These are two different concepts, but it binds states, and it binds those states that ratified the treaty. Now, how is this treaty making process? What is happening? I was, as Jenny indicated, I presented the Norwegian government in parts of the negotiations, everything that had to do with law. And negotiations are done by, every single country that is a member state to the UN basically is sitting around the table, and they have to find consensus. They have to find agreement amongst each other on how to address that global challenge of climate change, which is so complex. And there is no voting, there is no majority against the minority. Every single country basically have to agree. And in order to get everyone to agree on that general approach to climate change, that is a very difficult process, and that's why it took such a long time until we in 2015 managed to get the Piers Agreement adopted. As I already said, it entered into force in very record speed, just in less than a year. That is barely the case in international law, but it just proves the point that it was supported by a lot of political willingness, that so many states in so short time said we want to be bound by this agreement. Currently, we have over 190 parties, so it's almost a universal agreement. And maybe sometimes you hear that it's called, oh, it's not legally binding, but that's not true. The agreement itself is indeed law, it is legally binding, but it does have some provisions in it that are not of legal nature, but that is the case with all international agreements. And the last point here, yes, it was possible, it is possible to withdraw from the agreement, and we will talk a little bit about withdrawal in the end, because that is usually an element that needs to be part of an agreement, so that parties know that if something happens in their political landscape at home, they can withdraw. It's like a safety valve, and it's part and parcel of the overall compromise. Next slide, please. Just very briefly, I will talk about what the object and purpose is. You see it here. I have some copy and paste bits from the agreement so that you actually see what the text is. So the agreement is about enhancing the implementation of the convention, which is in the background, and to strengthen the global response to climate change. Next slide, please. And what you perhaps know, one slide back. What you perhaps know, what you perhaps know is there's a lot of talk about the goals of the Paris Agreement. I'll talk a little bit about what goals we have. It's not just one, it's actually 3, before I go into other must-know facts. Next slide, please. I will, after the goals, I'll say very briefly some words about the main tool, the NDC, National Determined Contribution, which each party has to submit. And then I'll say some words about differentiation between parties, because that is maybe the most sensible and difficult and sensitive issue that had to be addressed in the Paris Agreement. And then I'll say some more words on technical issues like the Paris Agreement's enhanced transparency framework and the process to increase ambition over time, or the ratcheting up process. Next slide, please. So very briefly, the Paris Agreement has 3 main goals. One deals with the temperature that is supposed to be the guardrail, the temperature increase compared to pre-industrial levels. The second one is that it has an adaptation goal in Article 2. And the third one, it also has a finance goal. But usually there's a lot of talk on that first one, and the other 2 ones are kind of forgotten, or they fall a little bit under the table. And that's why I included them here. Next slide. So the temperature goal is perhaps the one that you all know. It talks about holding global temperature increases to well below 2 degrees centigrade and pursuing efforts to 1.5 degrees. Now, 1.5 degrees was something that was added in the very last moment in the negotiations, but currently we see a very interesting move to focusing primarily on 1.5 degrees, because we've got the IPCC report on 1.5 degrees warming from 2018, which provided the science behind what is needed to keep warming to 1.5 degrees. And it seems that this goal, the 1.5, is getting much more traction than negotiators ever expected in Paris. The Article 4 specifies a little bit what needs to be done in order to reach the temperature goal. In Article 2, it talks about peaking emissions as soon as possible, and then rapid reductions thereafter, with the aim of reaching a balance between emissions and removals by the second half of the century. And that balance between emissions and removals is the same as net emissions, net zero emissions, or climate neutrality, where you just reduce emissions as much as possible, and what you can't remove is balanced out by increased removals, and the net sum is 0. Next slide. But in addition to temperature goal, we have the adaptation goal in Article 2, talking about increasing the ability to adapt to the adverse impacts of climate change, and foster climate resilient development, resilient low greenhouse gas emission development. And very importantly, also Article 2, paragraph 1, letter C, the finance goal, which talks about making finance flows consistent with a pathway towards low greenhouse gas emission and climate resilient development. And I mention this because we see now this general rise in climate litigation, as you probably are aware of, and I'll come back to it towards the end of my talk, where many times we see in these judgments references to the temperature goal. The temperature goal is used in order to interpret whatever governments or companies have to do. But it seems like judges haven't really looked at the rest of Article 2, because there are other goals as well, which can equally be used for interpretation of whatever needs to be interpreted, national laws or whatever. And especially the finance goal might be really important in order to interpret, for example, investment treaties, fiduciary regulations and so forth, because it deals with finance flows, and it is at the same normative level as the temperature goal, and can therefore also play the same normative role in domestic legislation and litigation as the other part of the Paris Agreement. Next slide, please. So let's move to the second part, the second must-know fact of the agreement. That's the cornerstone, that's nationally determined contributions, which every party has to communicate every 5 years. Developed country parties have to have economy-wide absolute emission reduction targets, and developing countries are encouraged to move in the same direction. That's written down in Article 4 of the agreement. Next slide, please. This one is an important one, which recently has gained maybe more and more legal recognition. The Paris Agreement also says that for each NDC that parties submit, it has to increase in its level of ambition. It will represent a progression beyond the previous NDC, which means that ambition has to increase for every NDC that is being communicated, and every NDC has to reflect its highest possible ambition. Now, from a legal perspective, you see that it says each party's successive NDC will represent a progression. Will is not necessarily legally binding language, but what we see is that in many cases, domestic climate acts have included these requirements of progression and highest possible ambition, and thereby included these the guidance from the international level into legally binding national laws. And that's when it becomes also reviewable, of course, by domestic courts. Next slide, please. Now, the NDCs are very interesting instruments. If you had a look at it, you may have seen that they look very differently from country to country. This is from a previous article that I have written with a colleague of mine. You see that they can be really like apples and pears, depending on countries' national circumstances, but there are some parameters around them that parties need to obey. But basically, what they write in their NDC, the target they put for themselves, is not legally binding. It is something that each party can decide for itself, and it cannot be bound by it under international law. But again, many of the NDC targets have been introduced or included in national climate acts, and thereby become legally binding on the domestic level. Next slide, please. I already mentioned that NDCs have to be communicated every 5 years. And you may know that currently negotiations are ongoing in the preparation for the climate summit in Glasgow at the end of the year. We just ended a 3-week online period of negotiations under what's called the subsidiary bodies. And one very sticky point of negotiations was, when is actually the starting point for those 5-year NDCs, and how long are they supposed to last? And in the Paris Agreement, there is no answer to this yet, but hopefully parties will be able to agree on that in Glasgow. Next slide. So this is the optimal. This is how the Paris Agreement was kind of designed to function, but some of the details are still missing. And what you see here is that the first NDC started in 2020, And then we have what's called the first global stocktake, which is in 2023, in 2 years from now, where collective progress is being taken stock of. And then the next round of NDCs should be in 2025. And then we have a next stocktake 5 years thereafter, and so forth. That it is supposed to go on. And for every NDC, the level of ambition has to increase according to that principle of progression, which I tried to draw into this diagram. Next slide. So the third must-know fact of the Paris Agreement is how does it deal with differences between countries? And this is it was a really sticky point, or in the negotiations, very hard to find common ground between different countries, because it's so linked to issues of equity, of justice, of historical responsibility, of capacity. And as you may know, in the Climate Convention, in the Framework Convention, there is this principle of common but differentiated responsibilities and respective capabilities, which basically means that every country has a responsibility to address this problem, but it is supposed to be differentiated depending on your amount of contribution and your amount of capacity to deal with the problem. And historically, it was interpreted that it only meant historical responsibility for developed countries, while developing countries weren't not really part of the responsible group of states. But this has kind of changed over the last decade or two, with a number of developing countries, of course, having become major emitters as well. And how to take this principle and put it in the Paris Agreement, as I said, was a really difficult negotiation part. And it was resolved by the end of the day by adding that language that I highlighted in red, where it says CBDR principle, but in light of different national circumstances, which means that you understand responsibilities and capabilities in light of each country's different circumstances. And that may be more than just historical responsibility. It could also be current responsibility or projected future responsibility for trajectories of emissions. This was something that actually China and the United States agreed on in the bilateral agreement prior to Paris, and then the rest of the world basically said, well, if the United States and China can agree, then why not everybody else? And then it was included in the Paris Agreement. Next slide, I'm sorry. So this is then reflected in the way that many of the legally binding obligations apply to all parties. It says each party shall. This is as much law as you can get in international law. If you see the phrase each party or every party shall, this is when we enter the realm of international law. And we have a number of these provisions in the Paris Agreement itself, and I included them here so that you can see how they look. For example, each party shall communicate an NDC, each party shall provide a transparency report, and so forth. But then there are some obligations that apply only to developed countries, as you see at the bottom two, where developed country parties shall communicate their financial contributions, or they shall communicate or provide information on projected levels of finance, for example. These are differentiated obligations which had to stay differentiated because they reflect obligations of developed countries that already were included in the Framework Convention on Climate Change. Next slide, please. So moving to the fourth must-know fact, that's the transparency framework. And transparency is an absolutely crucial element in the entire international climate regime, in particular under the Paris Agreement. Why? Well, as I already said, parties only have the obligation to communicate an NDC, but what they write in that NDC is not legally binding. And under the Paris Agreement, they have no obligation, legal obligation, to achieve their target. But they have to provide information to everyone, anyone out there, about how well they're actually doing in achieving their NDC. Although it's not a legally binding obligation, to achieve it, the information has to be put out there. And that is, of course, because the Paris Agreement is based on peer pressure, so that states can look at each other, how well are they doing. It's also based on pressure from the bottom, from stakeholders, from researchers, from media, who can have access to this information, and they can praise states when they're doing good, or they can be critical. when they're not doing good or not doing well, but the information has to be out there. So transparency is important to enhance trust and confidence that parties actually do what they said they would do in their NDCs. So the transparency framework is anchored in Article 13 of the agreement, and it gives some flexibility to developing countries. Important is also that the information that parties provide is reviewed by an independent technical expert review. Each report by parties goes through that independent review and is assessed for its correctness in terms of reporting requirements. And then by the end of that process, parties would also have to get together in what is called a facilitative multilateral consideration of progress, where parties can ask each other about maybe gaps, about challenges, about lessons learned, and share experience with each other. Next slide, please. The transparency report, this is now getting very technical. I just tried to make it short and concise. The transparency report, the information on how parties are doing is due every other year from 2024 onwards. Every other year, parties have to put forward information on their national greenhouse gas inventory, but also on their progress in implementing and achieving their NDC. And for developed countries, in addition, they have to include their support provided to developed countries in terms of financial support, capacity building, and technology support. So every other year from 2024 onwards, so we haven't really seen the start of this yet, parties will have to provide this report. This is really quite a significant obligation. It's a legal obligation in Article 13. Next slide, please. And as I already said, so the BTR stands for Biannual Transparency Report. That goes then to the technical expert review. And the technical expert review teams will also issue a report where they assess how well the party is reporting. And that then goes through the facilitative multilateral consideration of progress. So I'm sorry for these abbreviations and acronyms, but this is only to show you the flow through the transparency. And the fifth element that I think everybody needs to know about the Paris Agreement is the dynamics on which it is built. That is, it's built on an idea or principle of increasing ambition over time, picking up parties where they are right now or where they were in 2015, and collectively at common junctures in time increase ambition to where we all collectively need to be. So we have 5-year periods for NDCs. We have the application of those principles of progression and highest possible ambition to each of the NDCs. And we have these every other year, these biannual transparency reports. And every 5 years in between, we also have the global stocktake, taking stock of collective progress and the outcome of the global stocktake. Because the stocktake will always say, oh, collectively we're here, but science tells us we should be here in terms of our emission reductions. And that gap should inform the next round of NDCs and pull up ambition. So all these elements together need to be understood and need to be seen how they inform the push and the pull it sets on parties' performance. Next slide, please. Very briefly, the agreement itself, if you've seen it, is fairly short. It doesn't have very many pages, which means that not much detail could be agreed or was able to be agreed on in Paris. We knew that when we negotiated it and adopted it, that many of the detailed elements needed to be negotiated later. And that was done in the years from 2015 to 2018, where very detailed and hard negotiations continued on what is then called the Paris Agreement Rulebook, which was adopted in 2018 in Poland, in Katowice, in a very dark and cold winter COP, but it was very successful. And there are more specific elements I listed here on aspects of the Paris Agreement, which were necessary to make it function, to make it work. For example, on what kind of information parties need to provide in their NDC or on a global stock take. By the way, also on compliance and the role of the compliance committee. The Paris Agreement in its Article 15 established a implementation and compliance mechanism, which consists of a committee. And as Jenny mentioned, I'm currently the co-chair of that committee, together with my colleague Hasib Gohar, who is a diplomat from Pakistan. And that compliance committee can take up issues of non-compliance of parties. For example, if a party doesn't have an NDC or does not provide its transparency report, that is an issue that the compliance committee will take up. But it is of facilitative nature. It is not punitive. It is something that rather tries to get parties back into compliance than punishing them for not complying, because this is so much more important to make parties comply in the context of this collective action problem. What is missing from that rulebook, as you perhaps know, are rules for the carbon market. There's a mechanism under Article 6. There's also possibilities for bilateral carbon trading, and there's also a mechanism for non-market-based approaches. These rules were not adopted in Katowice, and they were not adopted in Madrid the year later. And the expectations are really high that they will be adopted this year in Glasgow. Next slide. Oh yeah, the last point in my previous slide, I'm sorry, was that in addition to the rules on carbon trading, there are no rules, thank you, on common timeframes. I also indicated that earlier, that it's not entirely clear how long each party's NDC should be. Some parties have NDCs that go over 5 years, some have that go over 10 years. There is no agreement yet. And now the next slide, and I just took a screenshot from a document that was released yesterday, coming out of the current negotiations that took place for the last three it felt like 3 months, 3 weeks. It's very, very small. You maybe not see it very well on the screen, but it's just a screenshot that shows you how negotiations look like, how difficult it is to reach consensus, because this is where parties are right now. They have identified four different options for common timeframes. For example, 5-year timeframes, 10-year timeframes, 5 + 5 year timeframes, or 5 or 10-year timeframes. And this is just typical for the negotiations in general, that if you have almost 200 very different parties, like you have tiny island states and you have big countries like China, everybody has a very different view, then you come from very different ends. And you have, in order to find common grounds, you have to see what are the different options, who has which position, and they come then in these papers, different options, different brackets around them. And so you work with text, and by the end of these negotiations, you hopefully arrive at a consensus agreement. But I have to say that the current pandemic and the situation that the negotiations have to go online doesn't increase the chances for agreement. It's actually it's always been really difficult to find consensus. Even if you met in person, it always took days and nights and years and, you know, cups of coffee and maybe dinners to find that sweet spot in the middle where consensus is. But now in that virtual world where you only see each other on the screen, you don't have these huddles anymore where you can just discuss things out. That makes it really, really difficult to agree on anything. Trust is the most central issue and the most precious one, and trust is really difficult to achieve online. Next slide, please. So where are we now? This moves into a more general discussion, leaving a little bit the Paris Agreement behind and moving into the general world of climate law. Where are we now? 5 years on after the entry into force of the Paris Agreement on the 4th of November 2016. In between, of course, we had the withdrawal by the United States and the re-entry only 3 months later. So it was only a short time that the United States were out. And it was very, very well received when the current President Joe Biden, on its first day of office, re-entered the agreement, because of course, the Paris Agreement wouldn't really work without the world's largest economy and second largest emitter. The United States have to be on board. And to be honest, the entire agreement, the architecture was built around the needs of the United States to become a party. I can go into some detail, but it was very clear at the forefront of the negotiators that the United States would need to be able to join, which meant that they could not put it to the Senate for ratification. So it needed to be an agreement which was able for the president to join by executive order, what both President Obama and now President Biden did. We also had this year a climate summit in the United States, conducted by the new administration, also with the climate envoy John Kerry now in place. And the United States submitted their new NDC, which was at a higher level of ambition than the previous one. So that was all very, very important. But we also see that many parties submitted updated and enhanced NDCs last year and this year as well. Of course, there were some delays due to the pandemic, but there is a request both in the decision that adopted the Paris Agreement, decision 1 CP21 for those who want to know, paragraphs 23 and 24, but also a recalling of these paragraphs in the decision from Madrid from 2019, that in 2020 parties should put forward enhanced or updated NDCs. And it depends a little bit of which time frame they had in the NDC. And many parties put forward new and updated NDCs last year and this year, but not all. But we know now how much needs to be done, how big the emission gap is. We have a synthesis report, we have an emissions gap report. We know that the current NDCs do not amount to the level of emission reductions that is needed in order to achieve the well below 2 or let alone the 1.5 degree temperature goal, so that they have to be ramped up and ambition has to increase. And there are, of course, more expectations for parties to come forward with enhanced NDCs, maybe prior or in Glasgow this year. What we're also seeing currently, and that's a fascinating phenomenon, are carbon neutrality targets that are being put forward. They're not in the NDCs. There are very few NDCs that put carbon neutrality targets in there. Some do. But they're basically for 2050 or for 2060. China, for example, announced a carbon neutrality target for 2060, and so did Brazil. Other countries, European Union, for example, has a carbon neutrality target for 2050. Germany now has one for 2045 because the German Supreme Court, the Constitutional Court, told the country to get better. But these are interesting phenomena which until a couple of years ago we didn't have, but they are a direct consequence of the temperature target in the Paris Agreement, and that reference to the balance of emission and removals by the second half of the century, but then also informed, of course, by the 1.5 degree IPCC report, which was very clear that it needs or global pathways need to be at lead to net net zero CO2 emissions around 2050, and we are around the corner from the 6th assessment report by the IPCC, which will come out later this year, which most likely will repeat this this necessity of net zero targets. Negotiations continue. As I already indicated, we will have the last COP, the international meeting of the parties, was in Madrid. There was none last year. And the next one is this year, hopefully, in Glasgow in the United Kingdom. There is no end in sight. These big meetings will continue, and they are probably an end in itself. The bits and pieces that are currently being negotiated aren't that terribly many. And hopefully they are resolved in Glasgow, but the meeting of both the states themselves is important, but also between states and stakeholders themselves, which is actually becoming much bigger than the negotiations in these summits, is a very important meeting and mingling space. Next one, please. So the expectations for this year is, of course, the completion of the Paris Agreement rulebook on carbon markets. That's Article 6 on common timeframes, as I already indicated. And then there's some technical aspects with regard to reporting tables for the biennial transparency report and for the technical expert review. And it sounds like it's technical, and it is, but there are always very highly political elements that creep into these negotiations. And I was listening to this for the last 3 weeks, and it's very interesting how difficult things become, although you would expect them to be, you know, after Paris, after the rule book, fairly easy and technical, but they never are. Updating, enhancing, I already mentioned. In Glasgow, we also expect the rules of procedure for the compliance committee to be adopted. This is what I'm working on currently the most. I have meetings with the committee several times every other month or something. We have the whole next week, we're going to meet to work on the procedural rules for the committee, which are not yet in place. And finally, there is an obligation to provide information for developed countries on how much finance they're going to provide to developing countries under Article 9, Paragraph 5 of the Paris Agreement. And these communications have just recently come forward, and they're very interesting to look at. And it's, as far as I know, the only agreement which sets a legal obligation to provide information on ex ante finance. You say now what you're gonna provide, rather than the other way that in a couple of years you provide information of how much you have provided. This is forward-looking, and it's very important because many developing countries need that kind of certainty of how much money will be on the table in order to decide what kind of level of ambition they can put in their NDC. Next slide, please. So, further implications of the Paris Agreement. I already indicated that many countries have included their NDC and their targets in national climate acts or other types of regulation, and thereby make them legally binding on themselves in their national regulation, national legal framework. This was it's very important development. At the same time, we see a global rise in climate litigation, as you perhaps are aware of, and many countries are individuals or NGOs or groups of primarily young people are taking countries, governments, companies, corporations to court for different things related to climate, but primarily, of course, for not doing enough, for not having the required level of emission reductions in their climate laws or in their corporate policy. And the most recent ones, as you perhaps have heard about, is from the Federal Constitutional Court in Germany, who found that the German Climate Protection Act was violating young people's rights to having liberty rights in their future, also to climate relevant behavior. It's a little bit of a difficult judgment, but it basically told the German government to increase its level of ambition and have concrete measures in its laws of how to achieve carbon neutrality by 2050. And interestingly enough, the German government reacted immediately and adopted a new law where they actually anticipated carbon neutrality to 2045 and acted and put this into their domestic act. The same in Australia, a very new judgment against the Minister of the Environment that she, in this case, she has to take into account damages to young people by climate change in all her decisions that she may take. And the same in the Netherlands, in Pakistan, wherever you look, you have this enormous rise in climate litigation. And it is primarily linked to the Paris Agreement, that the Paris Agreement is the background normative framework, which is being used in domestic litigation But also, of course, the science is clear behind climate change. And if you read the judgments, the judges refer time and time again to the IPCC reports. But also, of course, claimants become much more active. They're well connected. There are networks out there and databases about these cases, and information is immediately accessible. So that it's a global movement which is bringing these cases. The latest developments, as you may know, is the angle of looking at climate change through the lens of international human rights law, regional human rights law. Here in Europe, we have the European Court on Human Rights in Strasbourg. It's not the European Court of Justice, it's a different animal. It's European Court on Human Rights, and there we have now 4 cases. The latest one just 2 days ago from Norway, actually. We have 4 cases against member states to the European Convention on Human Rights, and all these 4 cases deal with the question whether the member states have done enough, or actually have not done enough, on climate change. And because they're not doing enough, that is violating the claimant's right to life and to private life under Articles 2 and 8 of the European Convention on Human Rights. And finally, what we're also seeing are very interesting references to the Piers Agreement in bilateral trade agreements, bilateral investment agreements, or free trade agreements. And I just included in my last 2 slides 2 examples just to show you how these things look like or can look like. Next slide, please. Well, this is small, but what it is the EU Mercure Draft, which is currently on hold. It's the attempt of a bilateral agreement, free trade agreement between the EU and the South American countries which set up the Mercosur free trade region in South America. And in this draft, there is a provision under the Sustainable Development chapter on trade and climate change. And you see here, this is a copy paste from the draft, how it is formulated, especially paragraph 2. Paragraph 1 refers to the Framework Convention on Climate Change and the urgent need to address climate change. And then paragraph 2 is really interesting because it says, pursuant to paragraph 1, each party shall. And again, we're talking, if this is adopted, we're talking about a legally binding international treaty between the EU member states and the Mercosur member states. And when it says shall, this is law, this is legally binding, and says each party shall effectively implement the Framework Convention and the Paris Agreement thereunder, and consistent with Article 2, promote the positive contribution of the trade to a pathway towards low greenhouse gas emissions and climate resilient development, and the increasing ability to adapt to climate change. And what you see here in this Article 6, paragraph 2, litera B, the last part, is copy and paste of the other 2 elements of the objective of the Paris Agreement, Article 2, paragraph 1, litera B and C, which set up this adaptation goal and that finance goal. So this is taken from the Article 2 of the Paris Agreement, where you can, argue whether it's legally binding or not, but it's put into the legally binding context of that bilateral free trade agreement, if it is adopted at some point. And the final slide here is, again, another draft of a free trade agreement between China and the EU. Again, this is not in force, it's not adopted, working on it. Doesn't look very good currently, but who knows? And here I just want to point your attention to litera A, where it also says each party shall, legally binding, shall effectively implement the Framework Convention and the Paris Agreement adopted thereunder, and including its commitments with regard to its NDCs. So here, what is very interesting is what is written in the NDC actually becomes legally binding in the context of that free trade agreement between EU and China. And this is kind of making the NDCs legally binding through the back door of an international bilateral free trade agreement, if it is adopted as it is, which I thought was a very interesting phenomenon, and something that takes the Paris Agreement content to a very new and much higher level. And with that, I'm done, and I'm looking very much forward to your questions.
Christina, thank you so much. So as one lawyer to another, who likes to I dot and T cross, to summarize 4 decades of climate change law in 14 minutes is a remarkable feat. I don't think I could have done that. But I think what you did do is highlight 2 things for our participants, which are really important and things that frustrate a lot of non-lawyers, and that's the nature of soft law. You know, when we get into international law, we used to in our national regimes of saying, you will do this, you won't do that. And in the international regime, we have a lot of, you should do this and you should strive to do that. And in climate change law, what you highlighted is the hard obligations of what you have to do are more about what you must put in place rather than what you have to achieve. So your comments about what's in the NDC, how ambitious they should be, whether you've achieved them or not, is an open question. And transparency then being the mechanism is important for all of us to understand. It's very frustrating. You can't put a country in jail. You can't make something a crime and put a country in jail. And I'm going to defer most questions on this until after other speakers have spoken, but there is one from Richard Worthington, which I'd like to raise, and he's asked in the chat box is about Article 6. And if in responding, you can remind our audience what Article 6 is. And he says, are the hopes high, or what are the ambitions, or what are happening with Article 6? And I think the thing is what we're all interested in is law has not quite got us where we want us to go yet. But if you could speak to that, that would be great.
Absolutely. And I could speak to that for the next hour. So I have to be very careful because Article 6 is an animal on its own. So for those of you for whom Article 6 doesn't say anything, let me just briefly say Article 6 is the article in the Paris Agreement that deals with carbon trading. And of course, emissions trading, international emissions trading is a means to reduce the costs of greenhouse gas emissions. You know, if you can trade internationally, you may be able to purchase cheaper emission reductions than what you can do at home. Or for some countries, it's another source of income if you have emission reductions that you can sell because you may not need them at home to achieve your target. So there's a very, very strong economic interest behind it because it could just simply reduce compliance costs. But it is also something that is very, very complicated, partly because we already have emissions trading under the Kyoto Protocol, but there it was only developed countries that could trade amongst them. In the developing world, there was a possibility to have clean development mechanisms, projects, but that doesn't really fit anymore into the context of the Paris Agreement. So the question is how to take what we have under the Kyoto Protocol and adjust it and transform it so that it makes sense under Paris. And here parties have all sorts of different views. And of course, it's also very important that the whole thing is environmentally sound, that it doesn't lead to some double counting and very creative ways of doing things, but it has to be robust and clear so that we don't count emission reductions twice, because that by the end of the day could increase overall emissions. And that is technical, that's difficult, it's also political. And this is where we haven't really seen much progress yet. What happened over the last 3 weeks was a lot of negotiations on Article 6. But what also happened is that yesterday or today, the UK presidency announced that it would ask the ministers, environment ministers from Singapore and Norway to conduct bilateral consultations now all the way to Glasgow. So now it's up on a ministerial level to find a solution to this problem where we don't have the rules in place yet. What also happened in the meantime, Article 6, as I said, has 3 elements. One is Article 6, paragraph 2, which deals with bilateral trading between 2 states. The second one is Article 6.4, which sets up a mechanism under the UN, which has been established, but it doesn't have rules yet, or not many. And Article 6.8 deals with non-market approaches. Under Article 6.2, where states can trade bilaterally, we've seen now Switzerland setting up agreements with Peru, with Ghana, and other parties probably following suit very soon, where they say, oh, we just do it. We don't need the rules under Article 6 decided, in Glasgow. We just do it. We use Article 6.2 as our starting point. There's some guidance there, and then we designed our own rules and start trading, and they can do that. And so the question becomes, how relevant are these rules actually for carbon markets to kick off? But yeah, we'll see where we are landing in Glasgow. What usually is the case in these negotiations is that they're a package deal. And what I've heard 1,000 times just today really was that what we need to agree on, what needs to be ensured is that no topic is left behind and not a single country is left behind. Each topic is equally important and we need to find an agreement on everything. So it's either everything or nothing. That is usually the dynamics that play out in these international negotiations. So hopefully parties will be able to agree on meaningful rules in Glasgow. Now they've had a lot of time to do so, and I think they made significant progress, and I'm quite optimistic.
Thank you, Christina. And I'm going to move on to other two speakers because I don't want to do them short because they've also got really interesting things to say. So our first one, and please do stay with us because I would like to take questions at the end, is Dr. Melanie Moocott. In the spirit of collaboration in Johannesburg, she is a senior lecturer in the Department of Public Law at the University of Pretoria. She also has a CV I'm not going to do justice to, but suffice it to say she's cum laude most of her degrees. And Melanie's particularly interested in social justice orientated law jurisprudence, and that's what a lot of her research focuses on. And she's also been quite focused on climate change litigation and how that impacts on that. So Melanie is going to give us a brief input on the South African perspective and how we're doing on the national legislation that Christina mentioned is important, and also her views on our revised NDC, which has pros, cons, fans, and oppositionists. So Melanie, can I ask you to turn on your camera and give us your input?
Good evening, everyone. Hi.
Hi, we can't see you, Melanie. Are you turned on your camera?
Oh, she is seen.
We can
You might see her, we can see her.
Okay. Okay.
Hopefully you can see me now.
Yes, there you are.
Great. So my role is to speak about some of South Africa's law and policy as a way of implementing the Paris Agreement. And South Africa has been a party to the Paris Agreement since 2016 and so produced its first nationally determined contribution at that time, and recently updated its nationally determined contribution. Now, South Africa has had climate change on its agenda long before the Paris Agreement, as I'll try to show you. And it's quite important that we do, because we have been ranked as one of the top emitters in the world, ranked 12th of greenhouse gas emissions. And per person, we're ranked as having higher than average emissions. So that our carbon dioxide equivalent tons per person are higher than average. And so there's clearly a need for intervention, and that intervention needs to come by way of effective implementation of existing laws, as well as the introduction of new, perhaps more rigorous laws. And so let's just, before I take you through, let's just briefly mention that we've got this rather interesting updated nationally determined contribution that came out in March of this year. And I've just put a link to it in the chat so people can have a look at it. And one of the things this updated nationally determined contribution tries to do is to commit South Africa to keep its carbon emissions to between 398 to 510 metric tons of carbon dioxide equivalent between 2021 and 2025, and then between 398 to 440 metric tons of carbon dioxide equivalent between 2026 and 2030. And that's an increased ambition from our initial commitment in 2016. And so it represents an advance in that respect. And then what the document says, it's quite a long document, it's quite complicated, is that the focus where these reductions in greenhouse gas emissions will be achieved will be primarily the electricity sector, and that will be by investing in renewables over the next few years. And then also from 2030, focusing on the transport sector. And so one of the key emissions in relation to mitigation, at least, is a focus on the agriculture sector, which also produces massive emissions in South Africa, and is a major mitigation challenge. So there are some positives and negatives in this document, but there are many who are very unhappy with it. And one example of people who are unhappy is a youth alliance who spoke in just a few days ago, actually, about how this new commitment is woefully inadequate, to use their words, and is a far cry from the ambitions that we need. And so there's a lot of criticism of this document as well, that we need something much stronger and much more ambitious. But this is really the current place where our government has put us. And the document was open for comments for just 30 days in March. And I was part of a group that has commented on it, particularly in relation to its lack of ambition around agriculture. And we'll see if anything comes of those comments. What the government has said is that this is not the second NDC of the country, so we can still expect a second NDC in terms of the Paris Agreement in 2025, but it is an update and an advance on the initial commitment. So much for the NDC. What might be useful is to consider the context in which this NDC arose from a law and policy perspective, and then where we're kind of going from a law and policy perspective. So I'll give you a little bit of a timeline, very brief, so not too much detail. So to start with, we had in 2004 our National Climate Change Response Strategy, and that's a policy document that tried to be responsive at a very high level, quite superficial, to the problem of climate change. But really the goal of this document was to put climate change into the national agenda. And then with that, at the same time, we had in 2004 the National Environmental Management Air Quality Act. And that act required that polluters apply for atmospheric emission licenses and also set minimum emission standards. So there was a goal of trying to maintain a certain level of air quality in the country. And then we had to wait a while, but we got in 2011 the National Climate Change Response White Paper, and that was a bit of an advance on the climate change response strategy. Again, a policy document really highlighting the policy agenda of the country in terms of promoting a low carbon economy and a climate resilient economy. And that was obviously a good starting point, but not concrete enough to bring about real change. But then in 2012, climate change was put on the National Development Plan as one of South Africa's key goals and key development areas. And there's a whole chapter in the National Development Plan on climate change. So again, a lot of dedication from the government to looking at a science-based approach to responding to climate change, to set targets and to determine our law and policy agenda. And then we didn't see too much from an environmental law perspective after that. What we did see is an unfortunate failure to effectively implement the National Environmental Management Air Quality Act. And so we had these emission standards that were set, and there was a timeline within which polluters had to achieve them. But then we saw that the government gave postponements to many of the biggest emitters and allowed them to continue emitting at a very high rate and a very problematic rate. And we've seen in our country huge amounts of deaths as a result of air pollution. And so we haven't seen this policy turn into practice in a meaningful way in many respects. So of course, people are applying for emission licenses. Those emission licenses are being granted, so to set thresholds within which pollution may occur, but they aren't onerous enough or stringent enough rather to effectively prevent damaging air quality that causes death of thousands of people every year. And then another important step in our regulatory landscape was that in 2017, we had our environmental impact assessment law be interpreted to require climate change impact assessment. So we always had environmental impact assessment law where before development could be approved, the impacts of that development had to be considered, but we had that considered to include climate change as a real issue that had to be considered before an approval could be granted for development. And this is a direct result of the Paris Agreement being acknowledged by our country, being ratified, and the court saying, well, given our Paris commitments, we have to, our environmental impact assessment law must keep up with that commitment. And so there we see the courts filling in a law or policy gap and making sure that we have climate change in the regulatory framework for environmental impact assessment. 2017 was a big year in other respects. Greenhouse gases were declared priority pollutants. And so that means that people, certain sectors or polluters who emit greenhouse gases had to produce pollution prevention plans. And then those pollution prevention plans had to be complied with. And if they were not, then there would be offenses and penalties that could arise. Of course, these pollution prevention plans are only as effective as they are enforced. And we have limited enforcement capacity in South Africa. So that's obviously a major problem and a major gap in spite of the best efforts in the law. But that was a big step in the right direction, I think, declaring greenhouse gases as priority pollutants. In addition, in 2017, we saw greenhouse gas emissions reporting regulations, which imposed an obligation on polluters to submit data so that we could have a national inventory of greenhouse gas emissions. So again, another good regulatory measure to keep track and promote a science-based approach to climate change responses. And then we have in 2020, the National Climate Change Adaptation Strategy. And there we have a range of goals and actions that must be put in place to adapt to climate change as a national policy. And in all of this, at the same time, in 2018, or around the same time, we had the climate change bill be introduced. And so that was another great measure that we saw. But the climate change bill is of course quite problematic. And one of the biggest problems with it is that it's still a bill from 2018 to today. And we've had many statements from the government saying it's been finalized. It was being finalized in March. It was on the road to finalization in 2020. We had public comments in 2018. And so it's a bit of a worry that it's still at the bill stage. And I've put in a little GIF, or rather a meme in the chat box, just to show you my overall thoughts about the climate change bill, is that it's a plan, and the plan is to follow the plan that we planned. And there's a lot that I could say about the climate change bill. I think I'm more or less out of time, but what I can tell you very briefly is that it requires, and this is a very good thing, alignment of laws and policies across all sectors and across all departments. And climate change mitigation and adaptation must be taken into account. So that's a great step in the right direction. It establishes a ministerial committee on climate change as well as a provincial committee. And then it requires a number of framework documents to be set up. So there's the National Environmentally Sustainable Development Framework for achieving its objects. There's within a year of it coming into enforce national adaptation objectives that must be set up. A greenhouse gas emissions trajectory must be set up that will be binding on the states and have reduction objectives. Sectoral emission targets must be set within 5 years. Greenhouse gas emission thresholds must be set. There's no specific time frame. The carbon budgets must be set pursuant to those greenhouse gas emissions. And those carbon budgets can then be applied to specific polluters, and those polluters will then be committing offenses if they fail to put in place mitigation plans and exceed their greenhouse gas emission allowances. And the offense that they'll commit will attract a fine of 10 million Rand or 10 years imprisonment or both. And those are some of the main measures to give you a very, very brief overview of that bill. We don't know what the act will look like and if it will resemble the bill, or if the comments that were given in 2018 will have informed the bill and strengthened it in ways, but we can hope. And in the meanwhile, we've seen some really positive steps in the courts. One of those steps is ongoing currently. It's referred to as the deadly air case. You can have a look at #deadlyair if you want to learn more about that. It's been brought by Groundwork and Vukani. It's not climate litigation per se, in the sense that it doesn't specifically speak to climate change, but it does speak to emissions and try and get government to enforce its emission standards and its obligations under the National Environmental Management Air Quality Act. And the positive steps that we've seen in the courts in the Earthlife case around the climate change impact assessment, and in the Philippi horticultural case also around taking climate change impacts into account, as well as in this recent case where we hope will have a positive outcome as well, raise the question of whether the legislature and the executive are going to keep pace with the judicial branch of government in promoting climate action in pursuit of the Paris Agreement. Thanks.
Great, thanks so much, Melanie. I think what you're highlighting again is the difficulties of law being implemented. But I know we're running out of time on this fascinating topic, so I want to introduce Mr. Louis Kuhn next, who will take the discussion forward. And Louis is going to look at where other legal regimes don't do well climate change law. So Louis is an assistant lecturer at UJ. He's a doctoral candidate, primarily researching the interaction between sustainable development, including the right to decent work and international economic law. And I don't want to take away from your time, Louis, so I want to get you going because you have quite an exciting thing to pick up also with what Christina said about raising funds for climate, meeting the climate change need.
Thank you very much, Jenny. So I'll try to be relatively brief, but what I'm going to touch on is how international investment law can actually be quite problematic. And Christina referenced the new free trade agreements that are now incorporating climate change provisions. But what we need to remember is that as of this morning, there are 2,298 bilateral investment treaties that are in force. Of those treaties, the vast majority of them are not reformed treaties. That is, they do not necessarily incorporate any provisions on environment. And there has been growing concern because these treaties are now being used to attack climate change mitigation measures implemented by various countries. And we have seen this particularly with reference to the Netherlands. So the Netherlands is currently working on a coal phase out. And earlier this year, we saw the case of RWE versus the Netherlands being filed at the International Center for the Settlement of Investment Disputes. And RWE is seeking 1.4 billion euros in compensation for the early closure of its coal plant. Now, we need to remember that is only one case. We then have another case that's also been filed against the Netherlands of Uniper versus the Kingdom of the Netherlands. And they are supposedly, we're not exactly sure of the exact amount because investment disputes aren't very transparent. For the most part, you don't necessarily know what's happening in those disputes, but it's reported that they are seeking about 1 billion euros in compensation. Now, what we have seen is that Germany has anticipated that it would indeed need to pay compensation under investment law, because we have the case of Santa Elena versus Costa Rica. Now, that is a relatively older case, but what the tribunal there said is that expropriatory environmental measures, no matter how laudable or beneficial to society as a whole, are in this respect similar to any other expropriatory measure that a state may take in order to implement its policies. Where property is expropriated, even for environmental purposes, whether domestic or international, the state's obligation to pay compensation remains. And to be very clear, within international investment law, an expropriation does not necessarily mean that the property is being taken. Indeed, prohibiting the use of coal can be seen as an expropriatory measure. In the past, we have seen a case where the state temporarily banned the export of cement to be determined as an indirect expropriation for which compensation must be paid. And the challenge we are also facing with investment law is the substantial amounts that are being awarded in compensation. The United Nations Conference on Trade and Development reports that the average award in investment arbitration is $550 million. When cases are decided on the merits, investors are winning 60% of the cases. To be very clear, there are reform efforts underway, and part of those reform efforts are indeed the FTAs that Professor Voigt has pointed out. But the many, many legacy treaties are not being reformed. And we also have another problem, that many new agreements that are being concluded don't actually contain any reform provision. So at the moment, we've also got reform efforts undergoing at the Untitled Working Group, but we've recently seen the working plan being released, and there are very, very serious concerns that the Untitled Working Group will actually not be addressing the problem at all. I think, unfortunately, I've run out of time, so back to you, Jenny.
Louis, thank you, because that's a whole area of research in like 5 nanoseconds, but it's an area that Louis has convinced me to get very concerned about. Climate addressment being impacted on. So in our last few minutes, and we only have a few minutes because we've been talking so much, but Mbali asks us, is environmental impact assessment different from a human rights impact assessment? Do we not need both? And I think, Christine, if you're still with us, I'd ask you to address that.
Well, yeah, I get, but yeah, we need both. I think there are more safeguards around human rights impacts because the body of law is just much older than the environmental body of law that many countries have. But we do see also a trend towards sustainable impact assessment, which look at both social and environmental impacts. But usually you have a set of social impact assessment regulatory frameworks, and the environmental impact assessment is just the newest one that comes in addition to it. And many countries don't have it yet or don't have sufficient regulation. That's why what Melanie explained in her talk, it was really important to have the court step in and say, well, environmental impact assessment also includes looking at climate impacts, and that's something that came from the Paris Agreement and was through the court interpreted or required into the legislative framework. But so absolutely, we need both, definitely, no doubt about it.
And then we've got Stephen Turner, who asked a question, but apologies, Stephen, I can't trace back the chat that far. Let me see if I can get it. Does the approach taken by the UNFCCC system fail to address the root causes of GHG emissions built into trade, company law, and tax law? And I think that's a question to you, Christina, maybe Louis, for a response.
That is a really excellent question, and a difficult one to answer. Because as Louis just just a brief pause, I just wanted to thank Melanie and Louis very, very much for both of their excellent presentations. I enjoyed both tremendously. I think that was such a rich source of information. But to Louis' point and his very important presentation on how investment law can actually obstruct countries' willingness to go ahead with ambitious climate legislation, that's a really important area to follow, and I would like to come back to it at the very end. What the Paris Agreement does is sets an overall trajectory for development within that safe space of 1.5 degree warming, or well below 2 degree. And in order to comply with that, in order to achieve that, that actually requires a complete transition of all sectors in each country's economy, but it also requires looking at other areas of law, trade law, company law, tax law, whatever you have. There is much more than these three, constitutional law and what have you, because it actually everything has to be aligned and transformed in order to address that massive challenge of reducing greenhouse gas emissions to that level where it needs to be. Carbon neutrality, global net zero emissions is going to be a very difficult target to achieve, and it really needs to have everyone and everything on board to get there. And I don't think we have seen yet the necessary legal reforms in all fields. And I think company law, investment law, trade law is something that definitely needs to be looked upon. And I can only encourage lawyers to go into these fields of law, which are, they're dominated by company lawyers, by corporate lawyers, and they're really good. But many of them don't know or don't care much about climate change or environment or whatever. They work in their own silo. So it's really, really important for lawyers who care and who have the capacity to look at what we have and what we need and what needs to be reformed, to go into these fields that are on the other side of the fence in a way, that are really difficult to access. But for example, the question is, how can we interpret the Energy Charter Treaty, on which the WRE case that Louis mentioned is based? How can that treaty be interpreted in a way that is dynamic and that reflects the global consensus on climate change? Is there a way? And that needs, good lawyers to go in there and provide good arguments. So I can only encourage every one of you to look into this field and work on it.
A final question from Stephen Turner is relates to Christina Louis' comments relating to investment agreements. Does sorry, my chat box is failing me. Does the approach taken by the
I think he posted it.
Huh?
I think
Maybe you can read it, because
Yes,
sorry,
I think you've asked that question.
okay.
Are you not able to scroll back because there are a number of questions here which haven't been addressed? I know we're running out of time, but I am able to put them just to the speakers for concluding comments. Sorry, people, if you want to bear with us for 10 more minutes.
Sorry, David, I'm completely frozen in my online room.
In your chat. Okay, so yeah. So if you don't mind, I will put those to people, and then we can. I'll just summarize them. And as I said, we've got just have 10 more minutes just to have the discussion. I think one question, Christina, for you relates to the feeling that people have in relation to COVID-19 vaccinations have been on their own. In all countries, there've been a retreat into nationalism, really, once again, in the face of a collective action problem. And the question is that going to harm in some ways climate negotiations going forward? Because developing countries feel, well, ultimately, the developed countries don't really care that much about us. I think that's kind of summarizing that question. And then I think there are two questions here relating to financing. How ambitious are developed countries in raising climate finance for developing countries, and the transference of technologies associated with reaching low carbon and resilient economies? And there's one also, will this climate financing follow traditional financing models, such as including structural adjustment programs? So I think that's a concern from in developing world. And I think that's most of it. I had one that I posted, which you don't have to address, but maybe perhaps touch on. And just is, I was wondering whether there are any, what's controversial about the procedural rules in your committee? Is there some desire to try and crowd out or stop participation or things like that? So if there's anything, I mean, but that could be just like a headline response. And then perhaps, Jenny, I'll hand back to you for taking over the chairing, and anyone else who maybe wants to may have concluding thoughts on these points.
And sorry, David, I got one message come through, and that's from another person saying, do we also not need to get in principle acceptance that deference to legal precedent acceptance that deference to legal precedent has diminishing relevance or legitimacy in a rapidly changing world? So, yeah. To our respondents.
But maybe Louis or Melanie want to go first? I don't know. I'm happy to answer.
Christine, start, please.
Okay, good. Well, given that we only have limited time, let me start with David's last question first and then work through them. The compliance committee, that is an interesting question. What are we doing? Currently, the meetings are not open. And the reason is that the compliance committee has never met in person. The members were elected in Madrid in 2019, and the first meeting of the committee was only last year, about exactly a year ago, which means that we have to find our way of working as a body, and that is really difficult in that virtual setting. You can't meet over dinner or coffee and just establish trust, and it has never happened to any of the other bodies under the Framework Convention. They all have met before, but the Compliance Committee hasn't, and for that reason it's a little difficult and challenging just to agree on something. But we're working on it, and we're trying as much as we can. There's some sticky points, reopening certain aspects that were negotiated. But we try to get there, and we have to have rules on transparency. We have to have rules on looking at different timelines for different countries depending on their capacity, giving flexibility to those who need it, and so forth. But it's difficult. It's a small negotiation setting, and we're only 23 people, it's 24 people. The second question on climate finance. Now, climate finance under the Paris Agreement is, of course, crucially important. It was part of the package deal negotiated and adopted in Paris. There are two aspects to climate finance. One is called the provision of finance, which means public finance. This is what developed countries usually pay from their ODA, official development assistance. It's public finance that goes to developing countries. But in addition to provision of finance, there's also another article that deals with mobilization of finance. And mobilization of finance is something that should go across all sources, public, private, whatever hybrid solutions you can find. And that goes into much wider ways of doing finance, and it should also lead to transition of the entire economic sector through whatever means we can find. But finance is and was and will remain a difficult issue. It's never enough money. It's never enough to provide for all the initiatives taken by developing countries. Developing countries are coming forward with quite ambitious own NDCs that do not depend on finance. But of course, in order to increase their level of ambition, there needs to be finance from developed countries. But it is a difficult topic, but one that will be high on the agenda in Glasgow as well. And finally, on COVID, that is a difficult one. Of course, COVID and the whole pandemic is just an example of how the climate challenge looks like. This collective problem that we're facing, the need actually to work collaboratively across borders, is just exacerbated from COVID to climate change. But when it comes to COVID, we've seen that many states are cutting back, becoming very nationalistic, focused, self-interested, although it is a global challenge. And that doesn't sound good for tackling the big problem, the huge elephant in the room. And it does impact on the negotiations as well, more in a practical manner, because parties cannot meet. They have to participate hybrid or online, and that leads to connectivity issues. And connectivity issues also have an equity issue to it, because usually it's developing countries that have, that fall out of the talk, and where the connection breaks up and so forth. But not only, it also affects others. But overall, it does impact the negotiations in the negative sense, because we just don't see the progress that we could have made if we had met in person. But what is, we have to use the means that we have. We cannot stop, we cannot wait until we can meet in person. And so it's the second best that everybody agreed needs to be applied and put forward. We cannot hear you, Jenny.
With Melanie and Louis, if they have anything else to add to those questions.
Yes, I'll just briefly add to Richard's question on precedent. Melanie has also addressed it quite well. But so in investment law, there is actually no doctrine of precedent, but that has also become a bit like the Wild West, because there are indeed contradictory legal doctrines, and tribunals from time to time adopt the sole effects doctrine, which doesn't consider the reason why a state implemented regulations at all. If it affects the investor negatively, you owe them compensation, done. It doesn't matter if the regulations are legitimate. Then we have the police powers doctrine that recognizes that states has the power to regulate. And a tribunal can choose any one of those legal doctrines because there is no doctrine of precedent. And indeed, in the Patrick Mitchell Annulment Committee, which considered the annulment of a certain ICSID award, the committee actually said that a tribunal always has freedom of judgment to choose what it wants to do. So I do agree with Melanie, we do need that certainty. It's one of the biggest problems in investment law, is that there's absolutely no certainty.
Thanks, Louis.
So Melanie, that leaves you with the last word.
Thanks, both Louis and Christina. It was really interesting and such an honor to be part of this panel. I think I've put a little link to Climate Tracker for people who might be interested. They kind of monitor whether countries are complying with their Paris obligations, and they say that our commitments in South Africa are highly insufficient to achieve the Paris goals that Christina was speaking about. And so I think I would like to close with a call to action. So those of you who are youth, take a look at African Climate Alliance. They've got a wonderful website, and there's a lot of brilliant work that they're doing to mobilize around climate change action. And those of us that are not youth, we need to be thinking about the big reforms that are needed in law, not just in environmental law, but in all areas of law. And we need to be the ones taking the action and pushing for the reforms in meaningful ways. And especially in South Africa, where climate change has such devastating justice implications for the 50% plus of our population who live in poverty. So that would be my closing remark.
Thank you, Melanie. I think that's a perfect closure. So thank you to all of you. Just brilliant presentations. Everyone's just brought fantastic insight. But the reality is we're all lawyers, and we know we work in a space where we understand that law is not perfect. So we do our best, we give our absolute commitment. But law is still an evolving discipline in responding to climate change, and we're going to keep getting there. We're going to keep striving and working with other disciplines and being a team. So thank you everybody.
And from my side, thank you very much to Jenny for chairing, and to Christina, Melanie, and Louis. Thank you so much for your contributions. This will be available soon on YouTube, and thank you to those who've been watching on Facebook as well. So with that, we close the seminar, and we look forward to welcoming you to our 5th part series, as I mentioned, on the 8th of July. Take care. And
Thank you so much.
Thanks,
Bye-bye.
everyone.
Thanks.
Bye-bye.
Bye-bye.
Bye, thank you.
There are thank yous in the chat, and people are expressing their appreciations.